What are the laws for car accident insurance claims in Ohio? Ohio auto accident insurance claim laws can be complex, especially when you're dealing with injuries, vehicle damage, and uncooperative insurers. Understanding your rights after a crash is crucial to protecting your financial recovery and holding the at-fault party accountable. In this video, we will break down what you need to know about fault, coverage requirements, and the claims process in Ohio. If you have been injured in an auto accident in Ohio and have questions about the insurance claims process, contact the Piscitelli law firm at 216-931-7000 or visit getfrankjustice.com to get a free, no-obligation consultation from an experienced auto accident claims attorney who can help you with your insurance claim and negotiation. Understanding Ohio auto accident insurance laws. Navigating an auto accident claim in Ohio can get complicated quickly, especially when fault, insurance coverage, and compensation are all in play. Whether you're dealing with your own insurer or the other drivers, knowing how the process works can make a major difference in your outcome. Next, we'll break down the key laws and steps that shape car accident claims in Ohio. First, Ohio is a fault-based insurance state. In Ohio, the at-fault driver is legally responsible for covering damages caused in a car accident. This is known as a fault-based system, meaning the injured party must typically file a claim against the other driver's insurance company rather than their own. The at-fault driver can be held responsible for medical bills, property damage, and other economic losses. Ohio law does allow for comparative negligence, which means that if you are partially at fault, your compensation may be reduced based on your percentage of fault. Next, it is important to understand minimum insurance requirements in Ohio. Under Ohio law, all drivers are required to carry a minimum level of bodily injury liability and property damage liability insurance. $25,000 per person for bodily injury. $50,000 per accident for bodily injury. $25,000 for property damage. These minimums may not be enough to cover the full extent of damages in serious crashes, which is why many drivers opt for higher policy limits or uninsured/underinsured motorist coverage under their own policy. Next, there are time limits on insurance claims/legal action in Ohio. Ohio generally has a 2-year statute of limitations, SOL, for filing most personal injury lawsuits related to auto accidents. This means you have 2 years from the date the injury occurred to file a lawsuit or settle your claim. Failure to file in time can forfeit your legal rights. Even if you're dealing with your own insurance company, delays can result in administrative denials. Claims involving minors or wrongful death may have different deadlines, so legal guidance is critical. It's also important to understand that the statute of limitations applies to lawsuits, not insurance claims. That means you don't want to wait until the deadline is close. You should have your claim filed or be working with a lawyer well before that point, so there's enough time to build your case, gather evidence, and negotiate properly before filing becomes necessary. How to file an insurance claim after an accident. If there are no obvious injuries, you can usually go ahead and file a claim with your insurance company or the at-fault driver's insurer. But here's the thing: not all injuries show up right away. After an accident, your adrenaline is high and a lot is going on, so things like whiplash, soft tissue injuries, or even head injuries can go unnoticed at first. That's why it's always smart to get checked out by a doctor before filing your claim. Once everything is submitted and settled, it can be really hard, sometimes impossible, to go back and get coverage for medical issues that weren't included. If you think you might be injured, or you do have a confirmed injury, it's a good idea to talk to a law firm first. A free, no-pressure consultation can give you some real clarity on your next steps before you deal with the insurance company. When filing your claim, you may be required to provide forms documenting the extent of your injuries and treatment. Submit estimates from a repair shop for vehicle damage. Prove lost income with employment records and tax returns. Justify any expenses related to a rental vehicle or car loan. Note: there is a good chance that the insurance provider will give a low-ball offer for these losses, or even outright deny coverage. You do not have to agree with the offer or accept the denial. This is where an experienced attorney comes in. An attorney will fight to ensure that the coverage adequately covers all current and future costs, and will fight for your rights as their client. Bodily injury claims and medical bills. These claims seek compensation for medical bills, lost wages, and non-economic losses like pain and suffering or emotional trauma. These claims often rely on thorough documentation, emergency room records, specialist referrals, and diagnostic imaging, proof of physical therapy or long-term care, medical opinions connecting the treatment directly to the accident, full assessment of future medical care costs. Insurance companies will likely try to downplay the severity of injuries, argue they stemmed from other causes like pre-existing conditions, or outright deny coverage. Having a personal injury attorney to oversee these claims can prevent costly mistakes and ensure you are covered not just for your current medical costs but for future medical costs as well. Damages that may be recovered through insurance claims. Depending on the facts of the case, compensation may vary depending on the severity of the injuries, level of property damage, and impact on your life. Common recoverable losses include medical bills, past and future, lost wages, pain and suffering, loss of earning capacity, damage to your vehicle, rental car expenses, interest on a car loan while the vehicle is unusable, emotional distress, punitive damages, damages that punish the at-fault party for gross negligence. These damages can be much more difficult to prove, but a good injury attorney has the resources and experience needed to make sure clients get fully compensated for these damages. How insurance companies evaluate and settle claims. After an accident, it's important to understand insurance companies are focused on paying as little as possible. Once a claim is filed, they start reviewing everything: fault, medical records, vehicle damage, and your overall losses, often looking for ways to reduce what they owe. They may offer quick settlements, question your injuries, or undervalue things like vehicle repairs or long-term medical needs. The problem is, those initial offers often don't reflect the full impact of your situation. Having a lawyer involved can change how seriously your claim is taken and help push for a settlement that actually reflects what you've gone through, not just what the insurance company wants to pay. What happens if the insurance company denies your claim? An insurance denial can happen for various reasons: disputed liability, missing documentation, delays in treatment, or violations of the insurance policy. If your claim is denied, request a detailed explanation in writing. Review the policy language with your attorney. File an appeal or file a lawsuit if informal resolution fails. You may still be able to recover compensation for all losses related to the accident, including medical expenses, lost income, and other damages. How to dispute a denied insurance claim. If your insurance claim gets denied, it can feel like a dead end, but it's not. Denials happen for a lot of reasons, like disputed fault, lack of documentation, or the insurance company downplaying your injuries. The key is understanding why it was denied and then building a stronger case to challenge it. That's where a lawyer can step in. They'll review the evidence, identify weaknesses in the denial, and work to prove both fault and the full extent of your injuries. And one important tip: be careful about giving recorded statements to insurance companies early on. What you say can be used against you later. With the right approach, a denied claim can often be challenged and pushed toward a better outcome. Here are the key steps in disputing a denied car accident claim in Ohio. 1. Obtain and review the denial letter. Understand exactly why the insurance company rejected your claim. 2. Gather and organize all evidence. This includes medical records, photos of the accident scene, repair bills, and documentation of lost wages. 3. Avoid further communication without counsel. Don't provide additional statements or documents until you speak with a personal injury attorney. 4. File an internal appeal. Your lawyer may challenge the denial through the insurer's appeal process. 5. Explore third-party liability, if other parties share fault. Example, another driver, a municipality for road conditions, they may also be pursued. 6. Initiate the legal process. If no settlement offer is made or accepted, your attorney may file a lawsuit to pursue compensation. 7. Engage in discovery. Through depositions and document requests, both sides build their cases and may reach a resolution. 8. Negotiate or proceed to trial. Many cases settle, but if not, your attorney will prepare for trial to prove negligence and seek full compensation. Piscitelli Law Firm, Ohio Car Accident Lawyer. At Piscitelli Law Firm, we understand the toll a car accident can take on your health, finances, and future. If you've been injured in an Ohio traffic accident and are struggling with medical bills, lost wages, or an uncooperative insurance company, we are ready to fight for your rights. Our experienced legal team has helped accident victims across Ohio pursue compensation for their injuries and losses, and we're prepared to do the same for you. We offer honest advice, strategic guidance, and strong representation every step of the way. Contact Piscitelli Law Firm today for a free consultation with an Ohio car accident lawyer. There are no upfront legal fees, and we only get paid if we win your case. Let us help you move forward with confidence.